Jethmalani, yesterday, everybody has gone through the corrosive leadership event for
Yes.
21st. Yes, you concentrate on correct, whether it should be what would the larger.
Yes, right. As for the rules framed by the Maharashtra Legislative Assembly, under paragraph 8, to reply within 7 days.
So the notice was not in accordance with Rule 73B according.
But that's the trigger, one of the triggers.
So then what is the next point then?
Next point is, whenever we ask for protection, we were told that if we come to Bombay, our dead bodies will be sent to a mortuary. Therefore, unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. How?
That's the point which we are addressing ourselves first. Can make your points ready for us so that we know what you're arguing.
Essentially, what I was in the case of the other side, that my notice of review, 179C notice, about which Nabab Media had elaborated upon, but it somehow froze the Deputy Speaker's power of disqualification. What are the other side grievance? Secondly, they are relieved by a prearrangement injunction of a bench of this court on 27th June, about which they say is contrary to Kyoto's judgment, paragraph 110 in particular. And then, my lord, the decision of the governor to order a floor test on the 28th. These are the three aspects, factual aspects, either by themselves or in conjunction with each other, which they say to be agreed by, which they say somehow curtail the jurisdiction, diluted it or restrained it of the Deputy Speaker's power of disqualification. But that's how I understand the case, Lord, and I've only proceed on that basis. And therefore, incidentally, Lordships seems to have a feeling that there is something wrong about Nabab Media's case regarding about the time period in particular, whether it should be from the notice issued under 179C or whether 181. The consideration of the resolution is the part from which the stay of hands by the Speaker should take place. But that's the short perspective of this case, and I'll address it very briefly. Now, the entire factual perspective is between a 9-day period of 21st June and 30th June, 2020. Everything happened in that time. About what happened that is so alarmed the other side or so prejudice them. On 21st June, I issued that notice under 179C. That notice asking him to stay his hand because he had lost his majority according to me.
Mr. Jethmalani, yesterday, everybody has gone through the corrosive leadership event for 21st.
Yes.
You concentrate on correct, whether it should be what the larger.
Yes,
That's the only thing.
But this factual perspective, actually already considered. Yes,
We considered and he considered.
But yes, the factual perspective has some bearing on that question. That's why I'm telling you, Lordship. I'm not going to go in any great detail. I'm just going to say that the notice which they are agreed by, in fact, was rejected on the 22nd itself. The notice played no part in causing any prejudice because I sent it on the 21st. They received it on the 21st or 22nd, as they said. And on the 24th, they communicated to me that this notice is without any jurisdiction. We have to verify. But I'll just show you the reply. Only that one document, your Lordship, may kindly see. What is their reply? Because much has been said about this 179C notice. And please see what their reply is. Now it's at PDF. Convenience compilation 1236. So, 223. Convenience compilation volume 2. That's the summit substance of what he said. Now, after this, I heard nothing more about this notice. What verification he had done. So, the case which is based squarely on this notice is completely misconceived because what happened, this notice disappeared. They didn't ratify it, they didn't tell me what happened. Now, what was the next step? Apart from dealing with the notice, he then said his name, a disqualification petition, a deputy speaker. A disqualification petition is sent as your lordship go to the 16 of the 34 MLAs. That's the next step. And the notice has no part to play in this case whatsoever. That disqualification petition is received by me on the 25th, admittedly, and I'm talking about the short period of time when the British took place. It's sent to me on the 25th with the direction to reply on the 27th. Now, my lord, your lordship will just note one more thing, that under the 8th paragraph of the 10th schedule, rules are to be framed. Rules have to be framed. They are called the disqualification rules. Rule 7 is that from the receipt of a petition by the noticee, by the person who is to be disqualified, he has a right to reply within 7 days. This is Rule 7.3a. Not added. It's right as per the rules framed by the Maharashtra Legislative Assembly under paragraph 8 to reply within 7 days.
So the notice was not in accordance with Rule 7.3b according.
But that's the trigger, one of the triggers.
So then what is the next point then?
Next point is we move the Supreme Court's Honorable Court.
Excellent.
And the bench, one of the grounds stating there, but it's contrary to Rule 7. Please give us extent.
Why 7th you move the Supreme Court?
We moved the Supreme Court on 27th. On 26th. Matter came up on 27th. Now, your lordship will just see that order. Because they seem to be aggrieved by that. The second aspect of this case which we are aggrieved by is that so-called Quia Tibet order of 27, which is not a Quia Tibet order. There are only two aspects of that order. Order dated 27.
Our court postponed the date for submission of the reply to 12th of July.
12th? And no, there's a very significant aspect also. I was in Guwahati at that. Now, not that it has a great bearing on this case, but I was given the protection order. Please see the last paragraph of that order. I complained that I'm in Guwahati. Mr. Shinde, the CCM, his son's office was burned. And I was receiving, the 34 MLAs were receiving threats. Very serious threats, which is part of an affidavit we submitted yesterday. And we asked for protection. We were told that if we come to Bombay, our dead bodies would be sent to a mortuary. So, this is what the court did. That's the only relevant part. Mr. Chittas, in view of these allegations, Mr. Chittas, learned counsel for the state of Maharashtra, states that adequate steps have already been taken and the state government shall further ensure that no harm is caused to the lives, liberties and properties of, by that time it had 12 to 39 MLAs, of the 39 MLAs and their families. So those are the two aspects of the case. How does that prejudice them? The state of Maharashtra voluntarily makes a statement. There is an explosive situation going on in the state of Maharashtra. These legislators and their family members don't threat.
Issue of whether or not to refer, Nabam, what is the sequitur so that you can formulate the point and tell.
Yes. Now, my lord, the not to refer is that all these aspects which they claim to be agreed by. Well, as I said, there are three aspects. One is the notice. The second is the Quia Tibet injunction, which is not a Quia Tibet injunction at all. No prejudice was caused to them. I know that this order was passed on the 27th. Please note, Parod, that on the 28th, the governor orders of notice. What prejudice has been caused to the speaker in the discharge, which was not of his power of disqualification? Wherein the prejudice which my notified will not have so profusely under the book. 28th, this protest is called the fundamental precept of parliamentary democracy is that the government owes collective responsibility to the Legislative Assembly, and as a collective body, the Legislative Assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or the lack of confidence in the Council of Ministers. We are therefore unable to accept the suppression of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. How is this different from the fact of the present case? On 28th, the trust vote was called for. It was held on the 30th. 29, they challenged it. It was repelled. Rightly so, because this court is repeatedly held that you can't injunct the governor for calling for a floor test or the holding of a floor test. So that what prejudice is caused to them? Exercise. Did you actually disqualify? You continue to have the right to vote and perform all functions of a member of a legislative assembly. So this one paragraph completely cuts the grass. So that this is another aspect, the quia timid injunction, and so these are the three aspects. The notice under 179C, which I said was stillborn because they said we don't accept this notice. Didn't have any further consequence. The quia timid injunction was necessitated by a breach of the rules on their part, giving me only 2 days when the Maharashtra Assembly rules framed, as I said, under paragraph 8 of the 10th schedule, gives me 7 days. I had to go to court, inter alia for that. Nothing, there was no quia timid injunction, there was no restriction on him. All they were told was, Deputy Speaker was told, please comply with your own rules, give them the time. That's all. And I was given a protective order because of threats to the life of me and my family members and my other 33 MLAs at that time, 38, with 39 MLAs at that time. So, my lord, nothing in this case has at all caused any prejudice, my lord, to the plenary powers of jurisdiction. There is no case for referral in my respectful submission. And my lord, just one more thing. Ultimately, one more factual aspect. On 29, the Chief Minister voluntarily resigned. His voluntary resignation was not the outcome of all that went before. He took a conscious decision. He knew he had lost the majority. And therefore he resigned instead of facing a floor test. So the floor test ordered on the 28th and to be held on the 30th was itself stillborn because the Chief Minister resigned on the 29th night, before the date even of the so-called floor test. So, my lord, in this factual conspectus, there is absolutely no reason, my lord, because nothing has caused prejudice. My lord, this is, with the greatest respect, my lord, on the other side, a case built on foundations of clay. There is nothing.
All right. Thank you. Anything else, Mr. Jethmalani?
Now, just one last thing on Nabam area. It's a lordship that a little, I'll only deal with that part of the I'm done.
You've dealt with Nabam Rabia. Your contention is that because the PM resigns, sir, and there was the 27th order of our court does not amount to any injunction on the exercise of powers by the Speaker. Yes, therefore, there was no question of Nabam Rabia being invoked here.
Your Lordship only want to do something about the notice period and that part, 181. If you are not, your Lordship don't need an argument on that.
No, they are not concerned with that. So far as the reference to Nabam Rabia is.
Yes, that's I'm deeply obliged. That's all I have to say.